Hello, and welcome to the EDRM Global Webinar Channel. My name is Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is a very scary EDRM collaboration with eDiscovery Today's Doug Austin, the important eDiscovery case law decisions for October of 2022. Our faculty experts are, of course, Doug Austin, the illustrious Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the console. This webinar will be recorded and available for replay at your convenience, as are all of our webinars. Please take a look at the little paperclip. It's the Attachments tab. You can keep up with eDiscovery news and education through subscribing to Doug Austin's eDiscovery Today blog. You can also learn more about how you can engage Judge Peck at DLA Piper to assist you. Check out Tom O'Connor's Spicy Techno Combo blog, and believe it or not, we're at the end of the year. Look for the most important eDiscovery case law decisions of 2022. We'll host that on eDiscovery Day, December 1st, at a little bit of a different time. We've got a link to that. And up next on the EDRM Global Webinar channel, eDiscovery Forensics for an Evolving Digital Landscape. You can download a certificate of attendance from the top of the viewing screen on the console after the webinar to use for your continuing education requirements. And now, Doug Austin. He is an established eDiscovery thought leader with over 30 years experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and government clients. Doug has published a daily blog since 2010, and these days it's not once a day. Most times it's 3 times a day. Welcome, Doug.
Thank you.
And Tom O'Connor, hailing from the great city of New Orleans for over 3 decades. He's stewarded the Gulf Coast Legal Technology Center, has a wonderful, engaging YouTube channel for long-form interviews, and he is a sought-out consultant on the largest cases. And he cooks a fabulous crawfish, I am told. And the Honorable Judge Andrew Peck is a Chambers-ranked senior counsel at DLA Piper, where he advises on copyright and trademark matters and also serves as a resource for the firm and its clients on litigation strategy and discovery issues from a judge's perspective. Judge Peck retired as the United States Magistrate Judge in the Southern District of New York after 23 years. He wrote many of our first eDiscovery opinions, and then later on, he wrote about things like boilerplate objections, 502D orders, and technology-assisted review. And EDRM is very grateful to all 3 gents for serving on our EDRM Global Advisory Council. And Doug Austin, it was so wonderful to see you at Fest, but you did scare me with all of these cases.
Well, Mary, it was great to see you as well, and Tom. So, yes, we do have a monster mash of cases with a lot at stake.
There's one.
And parties getting buried with sanctions. There we go. All right. And we even left out a scary $2.5 million fee award in the DR Distributors case. That's not part of the cases we're discussing today. But 4 of our 6 cases do involve requests for sanctions for spoliating evidence, including a pretty rare form of evidence today, paper. We also have disputes, including a motion to compel prior to meet and confer, and when to stop a TAR review as well. And just a reminder, because I know some will want to ask, we will send out a copy of the slides after the presentation, so don't be afraid that we'll forget that. Of course, any ideas expressed by us here today are our own, not those of our organization's clients or partners. Failing to say that would be scary for our organization's clients and partners. And before we get started with these cases, here's a quick note. My watch is talking to me.
It's a go.
Here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery Today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistance site, which is a great resource not only for case law, but also for federal and state rules, checklist and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has over 25,700 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. So with that said, let's get into the cases. Our first is an employment discrimination case involving a former employee of the defendant who was terminated after taking and extending a medical leave. Washington Magistrate Judge J. Richard Coutura reflected the discovery challenges in the case at the outset, noting the parties to this employment discrimination lawsuit have had repeatedly sought this court's intervention in discovery disputes, with defendant in particular often filing new discovery motions either immediately after the court's resolution of previous motions or while its own prior motions are still pending. Sound like somebody's maybe violating rule number 1. The plaintiff introduced documents during depositions that did not display bait stamps to indicate that they'd been produced in discovery, and also introduced documents that hadn't even been produced, claiming the mistakes were due to the sheer volume of documents involved in management of deposition exhibits in a separate software application, but defendant claimed that plaintiff did it intentionally for strategic reasons. Defendant requested a meet and confer with plaintiff, and as a result of the meet and confer, the plaintiff produced 200 pages to defendants at 11:39 p.m. the evening before a deposition. Defendant saw this as further gamesmanship to prevent meaningful pre-deposition review of the documents and ultimately canceled the deposition, partly because the deponent was scheduled to perform a surgery, but also said they wouldn't have allowed it anyway because of plaintiff's discovery abuses. Additional discovery disputes led to the defendant filing motions to compel discovery of all ESI exfiltrated by plaintiff during her employment with defendant, and for a protective order to require that plaintiff use only documents with bait stamps in depositions and produce all documents to be used in depositions 10 days in advance. The plaintiff complained that the defendant failed to confer with plaintiff in good faith before filing the motions, contrary to FRCP Rule 37A1. In denying the defendant's motion without prejudice, Judge Coutura stated, defendant's contention is without merit. Defendant has not indicated that it addressed plaintiff's objections to its RFP in good faith during the parties' meet and confer, as opposed to reiterating its prior accusations without accounting for plaintiff's objections or raising the privilege log issue. In addition, defendant's opening brief and reply identify additional concerns that could not have been discussed in the parties' July 28 conference, including the adequacy of plaintiff's August 3rd production and accompanying privilege log. Defendant's attempt to stretch the scope of the July 28th conference so as to encompass events that occurred afterward is unavailing. So, Tom, it looks like the defendant did request to meet and confer with the plaintiff at some point. Why do you think that wasn't enough for Judge Coutura?
I just also wanted to ask, Doug, did you pick this case because Judge Coutura's name looks incredibly like something that should be in a horror movie?
Yeah, well, I mean, it is kind of ironic that it's Judge Coutura is the first judge we picked today, but no, just a pure coincidence.
Just coincidence. All right. Well, I think there were a couple of reasons why it was turned down. One, as you pointed out, as you quoted here, there was no good faith discussion at the earlier meet and confer of an issue that was not put into play until after that.
Right.
And that clearly irked the judge, and issues were being raised that were either tardy in terms of what had gone on already, or there maybe had been raised, but the judge didn't find any good faith discussion of them in the first meet and confer, which, is going to irk them. But I think clearly, as you pointed out, it was the violation of Rule 1 that
Rule 1.1 to correct
1.1, excuse me, yes.
The unwritten rule.
The unwritten rule. As you cited in that very first paragraph, the judge notes that, quoting the defendant, in particular, was often filing new discovery motions, either immediately after the court's resolution of previous motions or while its own prior motions were still pending, end quote. And if you read the full opinion, I think you'll see other examples of the judge not being happy with the way the defendant was working here. So I think overall we've got a big fat 1.1 violation going on here.
Sure. Yeah. Agreed, Tom. And I almost asked Judge Peck a Rule 1.1 violation question again, but I've asked him those plenty. So I'll ask you a different question, Judge Peck, and that is, have you ever denied a motion based on a failure to meet and confer? And would you have done that here, since the defendant did request a meet and confer at some point?
Well, yes, I have denied it. And, I'm not sure if I would have done it here or not. At some point, the court has got to just, cut through all the nonsense, which the judge sort of did here. I also, have to remind everybody, but in the Southern and Eastern districts in New York, by local rule, a process that is encouraged by the amendments to Rule 16. So we have a pre-motion conference request by letter, which for discovery very often is the equivalent of the motion, but it doesn't involve, weeks or months of briefing. So it's a little easier to say, nope, go out and meet and confer and then come back. Indeed, there have been times where I sent the lawyers into the jury room and said, go really talk to each other and come back after that. So really is a question in every case for the judge to balance keeping a case moving, and that might mean taking on issues that were not met and conferred about enough, versus the parties to run to court without talking to their adversary. And, I just want to read one quote from the case, which gives you some idea of how the judge felt about these parties. And I quote, "The parties are reminded that the court has discretion to award sanctions against both or either the moving party or the non-moving party if the parties do not attempt to resolve these matters in good faith without court intervention," close quote. In other words, the next motion is, at one's risk.
Right. Yeah. Fair point. A question from the audience, since you're commenting on it, Judge Peck, they're asking, do you find that bad or lack of tracking discovery responses and production is a cause of some of these problems?
Sometimes, sometimes it's sloppiness. Sometimes it's a little more malevolent. But obviously, it is incumbent upon each side to keep track of what they have produced, what they haven't produced, and we didn't bait stamp it because it was discovery, deposition, as opposed to production. Come on, give me a break.
Yeah, right. Indeed. So, Mary, obviously, meet and confers are important in cases. What recommendations do you have for our audience on how to conduct an effective meet and confer?
Well, I have to refer to Judge Peck's, I believe it's yours, bring your geek to work comment.
That was me.
Yep. So bring someone who knows what they're talking about. And it's an opportunity to demonstrate your collaboration, your competence, your superior case. But that means nothing if you don't document what went on. The organization of the meeting itself, the aftermath. And come prepared with your claims and defenses, your time periods, the people involved. And these days, the privacy, the security, the data transfer protocols, what kind of affirmations do you make as you transfer your data, as you receive it, as you label it, making sure that perhaps you send the draft agenda and have someone from your team designated to take some notes. And bring along something to exchange, like a privilege protocol with a 502D order, perhaps a draft of one of those, or a protective order at the very least. You should come knowing whether or not hold notices went out to custodians and data stewards. You should know your discovery cutoff date and your scheduling conference dates. And then, of course, have a draft of everything that you'd like out of that meeting, abstract it up, and so that you can have a quick writing right back. And I'm sure you guys have got some tips and tricks as well, huh?
Those were a bunch of great ones, Mary.
Yeah.
So I have nothing to add at the moment. And in the kind of the consideration of time, I'll suggest we move on to the next case.
Okie dokie.
All right. Which is our first sanctions case, and it involves spoliation of PSI, paper stored information. Thank you. The case involved gender and racial bias and sex discrimination claims against the University of Idaho's law school, where the UI provost ordered a climate and culture review be conducted at the law school after multiple complaints about the climate, culture, and work environment occurred. During the review, Jennifer Counsel interviewed 32 of the law school's faculty and staff members, including the plaintiff and 2 other people of color, where employees confidentially shared their personal perceptions and experiences working within the law school, including their claimed experiences with racial bias. After the interviews were completed, Counsel drafted the College of Law Climate and Culture Review, which was finalized on April 17, 2018, which detailed some of the allegations of race and/or gender discrimination raised during Counsel's interviews. Counsel took notes during the 32 interviews and turned those notes over to UI's Human Resources Director after she finalized the CCR. Those notes were apparently shredded approximately 1 week after the finalization and distribution of the CCR, leading to a spoliation motion filed by the plaintiff. Regarding whether the defendants had an obligation to preserve the evidence, Idaho District Judge Lynn B. Windmill stated, "Here the CCR provided notice to defendants that litigation should reasonably be anticipated. The CCR states Human Resources is aware of the possibility that some of the concerns raised during the course of the Climate and Culture Review could rise to the level of what is considered discrimination, retaliation, gender, or sex discrimination." He also noted, as plaintiff points out, defendant's privilege log includes communications from April 2018. Judge Windmill also found that the defendants had a culpable state of mind in the shredding of notes, stating defendants were on notice that the information in the CCR was based on interviews, and this in turn gave notice to defendants that any notes from those interviews would be relevant to the concerns raised in the CCR. He also stated plaintiff requests a sanction of an adverse inference instruction. The court finds that sanction to be appropriate, but he found that a permissive rather than mandatory adverse inference instruction is appropriate. So, Judge Peck, given the sensitive and confidential nature of the interview notes, are you surprised that Judge Windmill issued such a harsh sanction against the defendants?
Well, I'm not sure it was that harsh. A permissive adverse inference is, this is what happened, ladies and gentlemen of the jury. You decide what that means. It's not a mandatory, you must decide that the notes are bad for the defendant. And I wonder if, part of the result here, you never know when you're reading these decisions what else was going on, is poor lawyering on one or both sides. I mean, it's not clear to me why, for example, the plaintiff could not interview or depose the people who gave their interviews to Counsel. Mm-hmm. So perhaps, particularly since it's pretty clear from that report that they largely agreed with the plaintiff that there was improper conduct going on at the university. So I wonder if that was argued by either side instead of an adverse inference. I wonder if the plaintiff lost the opportunity by not moving until discovery was over. Yes, the argument was they didn't know those notes had been destroyed until very late in the discovery period, but They probably should have found out about that earlier and thought about what else could be done. So I don't think the judge was too harsh here at all.
Okay. Well, and you raise an interesting point with regards to other resources or other sources, because Mary, I mean, it's not clear whether the interviewer kept a copy of her notes, but I mean, it wouldn't be surprising if she did. Couldn't the plaintiffs have issued maybe a third-party subpoena to her to obtain the evidence that way?
Exactly, but then you got the timeliness issue and the cutoff date. But I wonder, after something like a shredding of paper evidence, whose responsibility is it to do the third party subpoena? Is it the one who's being accused of spoliation, or the accuser? Which one?
Yeah, that's a fair point.
Depends on which court you're in front of, or at least which decision. I've read decisions going both ways under a 37E analysis, which of course doesn't apply here because, as Doug put it, this is PSI, not ESI. Period. Some courts say it's the person who's spoliated who needs to come up with the solution by saying, you can get it elsewhere. In another case, I'm thinking of, it was an auto dealership case, and the court said, well, you didn't go to each of the employees to see what they had personally, so you're not getting an adverse inference sanction against the dealership itself. Probably, I think it probably should be on the spoliator to try to, come up with the evidence from another source to avoid the spoliation. But it is, not clear that the courts will do that across the board.
Yeah, great point. Great question and great response, Judge Peck. Certainly interesting to consider that. So, Tom, do you think we'll ever see a day where we don't have paper evidence in discovery anymore?
Not in my lifetime. which admittedly is a shortening time frame, but there's just still too much filling. This case is an excellent example of what's out there that people don't tend to think of as being relevant evidence, right? But notes that are taking when you're doing something, whether it's conducting interviews. We see a lot of it down here in this neck of the woods with insurance companies, claims adjusters who are, supposed to use their tablets that are linked directly to their networks, but in many cases still do take paper notes when they're walking around after a big storm or a hurricane. I know a number of executives at corporations who are in the habit, and coincidentally, several of them are former naval officers, and I've often wondered if this is something that's part of their training for military officers. But they keep those small black and white cover notebooks next to their desk,
right?
And they use them for note taking during phone calls and meetings. And when they're finished with one, they label the date and stick it in a box and keep it in their office. And I've seen. They may still go and enter notes into the computer system, and et cetera, but there's just a wide range of paper documents that are still floating out there, not to mention some companies, and especially in state government agencies, that might still have a lot of legacy paper kicking around. So I think there's a lot of it. This discussion came up a lot last week at Relativity Fest. I was talking to some friends of mine who work for a national vendor called Array, which was not really a spin-off. It was started by the people who had started Advanced Discovery, which was bought by Concilio. Okay. And Concilio, when they bought it, said, we only want the eDiscovery piece of your business. There was a significant paper size. And so the founders said, great, well, we'll keep that if you don't mind. And we came to an agreement and spun it off. They've got like 7 offices around the country, one in Washington, D.C., where that's what they're doing is paper.
Right.
So there's a lot of paper out there, my friend.
Yep. Yeah, sometimes seems like it's we don't really cover cases about it as much anymore, but it's still there for sure.
Yeah.
So, Judge Peck, since you brought it up, since Rule 3070 is about ESI, what rule applies to failing to apply to preserve paper evidence?
Basically, common law and the standards in each circuit, which vary about what has to be shown about the destruction of evidence that should have been preserved. So in some cases, it's willfulness, in others, it's bad faith. It varies, but it's basically the decisional law of that state and or that district.
Okay. All right. Very interesting. By the way, I've got a question here. Are you going to make the PowerPoint available as a future resource for case sites? I believe last month the PowerPoint was not included in the attachments. I thought it was included as a link, AKA a modern attachment. But if not, I apologize. Reach out to me and I will certainly send it. But yeah, it will be included and sent out after the webinar, and it will be as a link. So look for it as a link to the file, as opposed to cluttering up inboxes with with a sizable file. So look for that, and we will move on to our next case. Which is we were talking about it earlier, the Twitter v. Musk case. In fact, probably the last ruling or close to it, as Chancellor Kathleen McCormick, in light of reports that Musk had revived the bid, stated, the parties have not filed a stipulation to stay this action, nor has any party moved for a stay. I, therefore, continue to press on toward our trial set to begin on October 17, 2022. However, the action was stayed the next day, and as we all know now, Musk's purchase of Twitter finally occurred. So this dispute concerned defendants' allegedly deficient production of text messages and Signal instant messages to and from Musk, where plaintiffs sought to compel production of all of Musk's messages from January 1st to July 8th of this year, and requested an adverse inference that defendants recklessly or intentionally deleted or withheld damaging messages, arguing, one, defendants unreasonably frustrated plaintiff's attempt to verify the adequacy of defendant's production, two, messages missing from defendant's production that were produced by third parties or appear in Musk's phone logs, and three, gaps in defendant's production at critical times when it seemed likely Musk was communicating by text. Plaintiff also argued that Musk sent or received Signal messages during the relevant period and that their deletion or non-production amounted to sanctionable spoliation. Regarding the text message arguments, Chancellor McCormick, one, stated the issue is largely moot, but to the extent that defendants have not yet produced a phone log that plaintiff is able to print, sort, annotate, and integrate into its broader discovery efforts, defendants are ordered to do so. Two, where plaintiff identified several text exchanges that were not produced, comprising less than 100 messages total, she stated, taken together, these deficiencies do not warrant sanctions against defendants for failure to produce responsive text messages. And three, ordered defendants to collect and produce responsive iMessages and non-SMS instant messages in Musk's files from May 24th through May 30th and June 1st through June 7th. And produce any messages pre or post dating this period necessary to place the messages within this period in context. When a second Signal exchange was produced after Musk provided an affidavit stating there were no more messages, Chancellor McCormick stated it seems unlikely that the two exchanges were the only times Musk chose to use Signal to communicate regarding the Twitter transaction. I am forced to conclude that it is likely that defendants' custodians permitted the automatic deletion of responsive Signal communications between them and possibly others, and that those communications are irretrievably lost. But since it was unclear whether the deletions occurred while Musk had a duty to preserve, Chancellor McCormick reserved a ruling for later, which turns out now to be moot. So, Mary, are you surprised that Chancellor McCormick found that sanctions weren't warranted for failure to produce responsive text messages when there were demonstrated instances of that failure? And Mary, you might be on mute.
Yes, indeed. That was a ghostly mute
Very
for
good.
you. Um,
I was scared for a minute.
So was I. So was I. Very, very scared. But this particular case with the way that people were communicating, so on email, on Twitter itself, inside Slack, inside Signal, inside proprietary Signal, the Andreessen Signal platform, or whatever they were calling it. So I wasn't that surprised, but I did like the way the judge said that she was going to wait pending a post-trial briefing when she had a fuller understanding of the record, because this case was just it was a moving target from the beginning. And so I would expect to see some things as this case and all of the follow-on and all the new ones continue. There's a lot of eDiscovery in this that we'll be able to parse out.
Yeah, absolutely. This I think I counted. I meant to get an updated count, but I think it was over 20 decisions in like about an 8-week period that were loaded up to eDiscovery Assistant. So a lot happening, and a lot of different varied data sources. So Confluence was in there, I think, as well. So absolutely. So speaking of one of those, Signal, Tom, do you think parties in litigation that are using ephemeral messaging apps like Signal should stop using them as soon as they anticipate litigation? If so, should they be even using them at all?
Well, there's using them at all is certainly a personal choice for companies, corporations, businesses, whatever. I don't know that we can litigate that. The rules are designed to talk about the rules at both the federal and the state level are designed to deal with people not saving things that they should. The choice of what tools to use, and absent some proof of fraud, deliberate fraud, I just think is that we're never going to go there. Should they stop using when they know or should have known? Well, sure. I mean, I think the federal standard is there. This of course is a state case. This is a Delaware case. I'm not sure what the rule was in Delaware, and in some states, I believe California is one. You're not required to preserve until you're formally on notice, either through a litigation hold letter or a demand of some kind from the other side. So I think what you're required to do depends on jurisdiction to jurisdiction. What should you do? I think, if you know that there's going to be litigation, it probably would behoove you to avoid any problems down the road to stop using ephemeral messaging. If the other side realizes that you've used it during that time frame when there's been some sort of informal discussions, a complaint by the employee, let's say, something that's gone on, it's just gonna raise a red flag that's going to lead to extended motion practice. So, good idea to stop doing it when you think that there's likelihood of litigation. Yes. Requirement, look to the rules in your jurisdiction.
Fair enough. I mean, I guess one of the things I'm wondering is, if you have to stop it when you're anticipating litigation, should you be using it to begin with? Not necessarily because there'd be a requirement, but just because then you have to switch to a different messaging app, which is always fun and challenging. So, but then again, who knows? So, Judge Peck, if this case had continued, what would the plaintiff have needed to demonstrate in order for you, if you were the judge, to issue adverse inference sanctions against Musk?
I mean, I would want to know about gaps in what was produced. I mean, that is usually evidence that something has been deleted or wasn't saved to begin with. Sometimes there's an explanation. There was a 1-month gap in something because the person went on vacation and worked for a company that actually let you go on vacation without being tethered to your smartphone. I would also want to know what information was provided by the counterparty to communications that the Musk side didn't produce, things like that. It should have been there, or I believe there are tons and tons of messages and they're missing. We saw that in the Romeo and Juliet case from Judge Cole that we discussed a long time ago. That doesn't cut it, but demonstrated gaps and demonstrated you didn't produce this, but your counterparty did, are the sort of things that give a court the ability to enter an adverse inference.
Yeah, that makes perfect sense. Well, we'll never know what would have happened in this case, alas, but certainly a very interesting one while it was going on. So we will move on to our next case, which is another spoliation case. This one involved copyright infringement claims over the defendant's marketing videos that the plaintiffs claimed included their copyrighted music. And in it, Florida Magistrate Judge Jacqueline Becerra stated, there is no dispute that some of the videos at issue were not preserved at all, and there is no dispute that many of the videos that were produced were not preserved with the engagement data, i.e. how many views, how many likes that defendants should have preserved. So the discovery cutoff in this case was May 12th, but the defendants failed to produce the videos after each of 3 hearings, even though they were ordered to do so. Following another discovery hearing, the court issued an order on May 26th, permitting plaintiffs to file a motion for sanctions regarding defendants' repeated failure to preserve marketing videos. Interestingly enough, due to the court's discovery procedures, plaintiffs were not permitted to file a written motion on the issue without leave of court. So there were 2 sets of videos at issue in this case, 22 unproduced videos and 171 videos that were eventually produced, but without engagement data that were known as the data-free videos. The plaintiffs asserted that the spoliation was in bad faith, that they were severely prejudiced by the failure to preserve marketing videos, and they proposed an adverse inference sanction for each video at issue. They also filed a notice of supplemental authority, which alerted the court to an order in an almost identical case involving the same kind of videos with the same defendant. Regarding the unproduced videos, Judge Becerra stated, the undersigned finds that defendants' conduct here was in bad faith as defined. Defendants were well aware of their duty to retain the videos, having been asked to do so as early as April 13, 2021. It is unclear why defendants were unable to produce these 22 videos prior to the discovery cutoff, yet somehow were able to produce videos and or corresponding screenshots of them afterwards. Such actions deprive plaintiffs of crucial evidence to which they were entitled and cause them prejudice, as they cannot adequately address them in this case, which they're clearly entitled to do. She also found that the failure to preserve the engagement data for the 171 videos was in bad faith, finding the plaintiffs were prejudiced in the same manner and awarded sanctions and attorney's fees and costs. So, Tom, have you ever seen a ruling where a judge was able to reference a virtually identical case involving the same defendant in making their decision?
Well, all the time in criminal cases with the federal
Sure.
defenders. Astonishingly, criminals tend to repeat their behavior, and judges tend to catch them at it.
Mm-hmm.
So, yeah, in the criminal arena, not too bad. In not too uncommon. On the civil side, I've not seen in a single party or what we would call a standard case. A couple of times in MDLs, right, where you've had repetitive actions against the same set of defendants, either in lower courts before they've been combined, or in the course of the MDLs. I've seen that happen several times, but it's rare. Sure.
Okay. All right. So, Judge Peck, the plaintiffs weren't allowed to file a motion for sanctions until the court gave them leave to do so under the court's discovery procedures. Is it common for courts to be that restrictive in terms of when motions can be filed? And did you ever apply that level of restrictions on parties in your court?
Yes. It's more common for substantive motions than discovery. And I guess the sanctions are closer to a substantive motion. I mean, the whole purpose of the courts like Southern and Eastern District in New York, like one of the commentators said, Judge Ali Goddard in San Diego federal court, to say you got to have a good faith meet and confer, and then you've got to, by letter, request permission to go further. The idea is to head off at the pass motions that are either not ready for prime time or where the court can, based on the letters and perhaps a hearing, deal with it without extensive briefing. Because sanctions motions tend, in many cases, to get responded to with a, well, you're moving against me for sanctions, so I'm going to move against you for sanctions, and everybody getting very hot and bothered, etc. I can understand why the court wanted to get the motion only, at the right time, etc. So it's not at all unheard of for judges to say you can't file a motion until I give you permission. There is circuit law. I know of the Second Circuit case on this that essentially says judges can't prevent you from making a motion that is allowed by the rules. That won't, great. You can, cite that to the district court. Doesn't mean the court is going to rule on your motion before, trial or before, years go by or anything else. So there's the official, we can't stop you from making a motion. There's the practical, that many courts have pre-motion requirements.
Okay, very interesting. So another thing that was interesting about this case, Mary, is I think it's one of the first cases I've seen where social media engagement data has been part of discovery. So what recommendations do you have for our audience on discovery of social media content and engagement data and stats?
Well, the content and what the affidavit stated was that they didn't intentionally delete the engagement data. They took down the social media posts to comply with plaintiffs' demands, and then they couldn't locate them or reproduce them because of the nature of how they were stored. So that's similar to getting rid of a custodian's mailbox when they leave a company. Sometimes things are just lost if you do it that way rather than archive, and other dynamic types of data where you might want to take it just like a point-in-time report, much like you do a point-in-time backup if you were preserving like whole groups of files. Here, you're trying to produce the state as it was, much like in that Salesforce case that had the dashboard that wasn't preserved the way that the court or the parties wanted it to. So in terms of marketing systems with this engagement data, you need to start talking to your marketing folks. It's no longer the CIO. The marketing folks have budget for all sorts of ESI trackers and statistics and assets. So they're called social listening apps. And some of them are called like Agora is one of them. Pulse is another one. If you look at some of our product service showcases that we've had recently, our trusted partner Ona, X1, Page Freezer, Hanzo, those are organizations that may be able to get you what you need as well. And don't forget your easy button from whatever platform you're on, like say, for example, Twitter. You will need passwords and a two-factor authentication if that's enabled, but that's also a way where you can get some stats on an individual basis. But more than likely, you're going to want a more global view, so you need the listening systems of the entity that you're dealing with.
And if I could jump in, I mean, I don't remember if the opinion said it or I just deduced that these sounded like little TikTok videos. And I suppose the views of it or things like that could be relevant to damages in the case. If the video were viewed 1 million times, damages might be much greater than something that was only viewed 50 times or whatever.
Right, absolutely. Yeah, I think that's what I assumed as well. I'm not sure if they specifically mentioned the types of videos they were, but that seems like a safe assumption. And yeah, I think the one thing that Judge Becerra didn't grant for the plaintiffs is I think they were looking for the ones missing engagement data to be kind of assigned to the highest ranking ones, and instead I think she more or less said, well, assume they're about the average. And that was, and obviously that does factor in. So that's a great point and great information, Mary. A lot of platforms are out there that do track that sort of information, and obviously you want to have a plan for it. So yeah, it's an interesting case and very interesting kind of consideration. So we will take a break from spoliation cases for a moment to cover something much more rare these days, a case involving technology-assisted review. I don't think we've really had any this year because I haven't really seen any. But in this MDL litigation, disputes over search terms and the TAR approach and motions filed by both sides led the court to appoint retired Judge James Francis as eDiscovery Special Master, with the task of providing a recommended disposition of the motions. After attempts to resolve the disputes were unsuccessful, Judge Francis issued a report and recommendation in August 2021 recommending both motions be denied. The defendants decided to modify their TAR protocols to address the flaws identified in that R&R, representing that if the parties did not agree on search terms, they would apply their chosen terms but perform a validation analysis that covered the search term phase as well as the TAR phase of the process. They also committed to share with the plaintiffs the number and content of responsive documents identified in the last two batches of documents processed by TAR when they proposed to conclude their search. The plaintiffs objected on several grounds to that approach, but the court overruled plaintiffs' objections and adopted a defendant's approach in full. The defendants proceeded with their review, and all the defendants stated a recall estimate of between 74% and 89% when done. 3 of the defendants stopped their TAR review when the percentage of documents that were responsive were all above 10%. Actually, they were 15% and higher. The plaintiffs issued several challenges, including the TAR results, and presented a declaration from their expert, Dr. Moore R. Grossman, who opined that the defendants' recall estimates are overly rosy because they were not calculated using blind stratified samples, and that the problem arises because qualified independent reviewers disagree about the proper coding of a document about 30% of the time. They also challenged the decision of 3 of the defendants to cease their TAR review procedures when they did, having advocated that review continue until a 5 to 10% responsive rate occurred in the last 2 batches. After a lengthy analysis of the search terms, including highlighting of several documents, Special Master Francis disagreed with the plaintiff's analysis that responsive documents were proven to have been missed, stating the better conclusion is that defendants' search terms were robust enough to capture many of the same documents that the disputed terms would have, without bringing in volumes of additional non-responsive documents. This does not mean that the disputed search terms would not yield many additional responsive documents. They would. It does not mean that the defendant's search terms are perfect. They are not. But the parties agreed that the defendants could use search terms to narrow the population of documents to be presented to the TAR tools, and the search terms utilized by the defendants have not been demonstrated to be unreasonable. Also, after conducting a proportionality analysis on whether to continue the TAR review process, Special Master Francis stated, on balance, then, the proportionality factors favor requiring WCA, Huntsman, and Covestro to continue their TAR review. To reduce the probability of further dispute and provide the parties with a benchmark, I recommend that each review may presumptively be terminated when the last 2 batches reviewed contain no more than 10% responsive documents. So, Judge Peck, you once cited Sedona Principle 6 in Hiles v. New York City regarding the use of TAR. Does the fact that this is an MDL case change the equation regarding what the plaintiffs can dictate to the defendants on their use of TAR?
I don't think it's because it's an MDL case, although obviously that means there's a lot of money at stake. I mean, Sedona Principle 6 says that the responding party generally is in the best position to determine what method it will use to search for and produce responsive documents. And that's why in Hiles, even though I told them I like tar better than keyword searches, I didn't order the city of New York to use tar when they didn't want to. That doesn't mean that whatever process a party based on Sedona Principle 6 utilizes, that it's not challengeable. So here, the various defendants got to choose to use tar, and in prior reports and recommendation, Judge Francis dealt with all of that, but he had specifically said that quote does not immunize the defendant's production from challenges at the end of the day. And this wasn't quite the end of the day, but it basically is, okay, you wanted to use tar, you wanted to use certain recall parameters. Now, on challenge, the court gets to decide if the recall parameters, or in this case, the stopping percentage, was appropriate or not. So it's all consistent with Hiles and Sedona Principle 6 and other cases along this area. And not to step on other people's toes, meaning Mary and Tom's questions, but a 15 to 19% relevance, and yet the parties decided to stop review at that point. I don't know what they were thinking. It's much too high a number. I mean, really, it means 1 of every 5 documents looked at were relevant, and you're going to stop reviewing at that point. Oi, is, technical legal term. Oi.
Yes. Well, yeah, that indeed does seem a bit high, and yeah, absolutely, and great points, Judge Peck. So another consideration in this case, Mary, what do you think about Mora's statement that qualified independent reviewers disagree about the proper coding of a document about 30% of the time? Do you agree? And if so, how can we ever expect accurate tar results if that happens?
Well, that did scare me, so I went and looked, and there are some studies, not a lot of them, but there was one conducted by Discovery of Electronically Stored Information, the DESI workshop, and they found 7 teams differed significantly on the percentage of documents to be responsive, as they reviewed the same set, ranging from a low of 23% to a high of 54%. And additionally, the overall agreement between various pairs of reviewing teams ranged from 65.5% to 84.9%. And so that, that gets you into the ballpark of 30% there. And then Herb Royblatt, Ian Kershaw, and Patrick Hoot had a study as well. And their numbers were even worse for agreements amongst reviewers reviewing the same documents with the same set of instructions. So I think we have to give it to Mora, and I also think we need some more studies in this area.
Yeah, absolutely.
And, but if I can jump in, I mean, sure. That's one of the benefits of tar. Tar will, assuming no other input from the human reviewers, a well-trained tar tool will reach the same conclusion about any particular document pretty much every time. So the reviewer issue becomes, I think, and I believe this is what Mora was arguing over, where there was reviewer overturns of the tar results. So in other words, the tar process would say, I believe these 10 documents are probably responsive, and the human reviewers would look at it and say, no, they're not. But where the human reviewer is agreeing with the tar assessment, I think you're in much better position to have, much better than a 30% agreement or whatever. And it's, another reason why the old-fashioned lawyers who believe that eyes on human review is the best method of deciding what is relevant is just not correct in the modern world.
No, fair enough. Comment from the audience: when have a group of gathered attorneys, more than one that is, ever agreed completely? So
I would say that depends. What do you think, Judge?
that depends.
Oh.
Right?
Yeah.
The common attorney answer, right? So Tom, variation to what Judge Peck's already talked about, but do you think a 10% responsive rate to stop TAR review is appropriate, or do you think it depends on the case?
It depends, obviously.
Oh, there we go.
And there we have it.
No, here's the thing. I agree with everything that both Judge Peck and Mary have said, but it's these sorts of arguments that have the average attorney throwing up their hands and saying, I don't really understand what you're talking about. If you're lucky enough to have somebody like Maura come in and explain some of this to you, if you're lucky enough to have a juror like Judge Francis in this case, as a special master, in the good old days when Judge Peck was talking about these cases, that's great. But I think most of these discussions, people on all sides get really slogged down with lack of fundamental understanding of the technology. And so that they just kind of throw up their hands. And, what I thought was really telling here was that Judge Francis finally, not finally, but at one point said, look, I'm turning to a proportionality analysis here, right?
Right.
I'm going to look at this from the point of view of let's not get bogged down in the technology. Let's take a look at what this is costing in time and hard costs. And as Judge Peck said, let's look at things like the Sedona principles, and think about a way to handle these things in a more straightforward manner without getting too bogged down in the mires of technology, and not technology per se, but the discussions of technology,
Right,
which tend to be imprecise.
And this sort of thing is one of the reasons that some lawyers don't use TAR.
Yeah.
Not only are there the attorneys who don't understand these sort of arguments, but there are those who understand it very well, but say, whatever costs we're going to save by using TAR because it's more efficient, we may well lose because of motion practice in front of the court. I mean, this was the third, I believe, decision by Judge Francis as the special master.
Right.
It went up to the district judge twice. There was briefing on all of that. Did that, dissipate whatever the cost savings from using TAR were? Maybe, maybe not. We don't really know what the lawyers were charging. But, Maura Grossman was the expert for the plaintiffs.
Mm-hmm.
Dan Regard, our friend, from Tom's neck of the woods, originally was one of the experts, or the expert for the defendants. I mean, that's a case where there's a lot of money involved when you've got folks like that as the experts.
Yep. Great point.
Great point.
Yeah. And of course, everybody understands search terms, so that's why we don't have as many disputes on those. Right. Indeed.
I did notice, Doug, that you didn't dare to pronounce the name of the case. Which we have now finally, I think, learned is D-isocyanates, which I can do when I've got the spelling in front of me and otherwise can't. But thought I'd throw that out.
Yeah. Fair enough.
I appreciate that. Thank you.
Yes, thank you, Judge Peck. I was not going. I stumbled over enough words. I wasn't going to try that.
Yeah, I wasn't even going to take a shot at that.
All right. So we have one case left, and we are almost at time. So we will rush through this case quickly. We do respect your time, and if you have to jump, there will be the recording, so you can catch up on it. But we will jump to it quickly. And it's our last case is deja vu all over again. It's another case involving spoliation sanctions regarding Slack data. In this trademark infringement case, the R&R issued by the magistrate judge summarized the relevant facts associated with the defendants changing their Slack retention policy as follows. From 2017 to present, Teledrip has used Slack as a typical mode of communication for both internal communications as well as customer communications. On October 25th, 2019, defendant Taylor Murray downloaded a portion of the Slack data, which did not include Slack channels containing internal communications. On October 28th, 2019, Murray changed the retention setting of Teledrip Slack from unlimited to 7 days and deleted the previously exported Slack data. On November 26, 2019, Drips brought the instant action, and the following day, Teledrip received a litigation hold letter from Drips along with service of the complaint. Teledrip did not change the 7-day retention policy for its Slack communications until September 2020, I should say. Ohio District Judge John Adams, certainly in his ruling in those middle 2 bullet points, illustrated that it was reasonably foreseeable in terms of litigation, that is. So I won't read those points per se. You've got them right there. So I'll jump down to his finding, which was finding also that the defendants had a culpable state of mind. Judge Adams stated, it is not disputed that on October 28, 2019, defendants changed their Slack retention settings from indefinite to a 7-day retention period and deleted all its Slack data up to that point. It is telling of defendant's state of mind that they admitted to intentionally deleting and changing the retention policy after they became aware of litigation. Defendants do not object or otherwise contest the R&R's conclusion that Slack was their primary mode of communication. However, Judge Adams disagreed with the R&R recommendation of a permissive adverse inference instruction for the defendants and instead imposed a tougher sanction, a mandatory adverse inference instruction sanction. So, Mary, it seems as though we're seeing more cases with severe sanctions lately. Do you think this is happening because of general ignorance of the rules, presumption that data sources like Slack won't be discoverable, or both?
Well, I think it's the pendulum. I think the pendulum swung to very, very, very severe sanctions early in our eDiscovery world. And then with the change in rules, 2015, we've seen the pendulum swing to the other side where there were absolutely no sanctions. And I think we're swinging back into, okay, there's some parties that are having some terrible behavior and they're going to get some serious sanctions. So demonstrating intent to deprive is not easy. And that's what our miscreants have done here. They had selective delete, a 7-day retention after the fact so that things that get deleted off. So I think people's behavior is very, very fast and loose right now.
Yeah. It's like there's a full moon or it's Halloween or something. So Tom, what recommendations do you have for our audience on retention destruction policies for data for collaboration apps like Slack?
Well, in the spirit of brevity that you mentioned, I'll just keep this brief. Don't change your policies after notice of litigation. Duh.
Well, there you go. Yeah, absolutely. And that's really true of any source, not just collaboration apps.
Yeah. I mean, no big mystery here.
Yeah, absolutely. So Judge Peck, I was surprised to see Judge Adams actually increase the strength of the sanction. Have you seen that before? And were you ever involved in a case as a judge where that happened?
Well, I would like to say I was never reversed or modified by the district judge, but that wouldn't be true. I do like it when I read decisions where the magistrate judge's decision is upheld by the district judge. But in this case, the argument that they didn't want to keep stuff because of the CCPA and ISO standards, which the magistrate judge found to be plausible, I agree with the district judge that that did not pass the smell test and that the mandatory adverse inference was indeed justified.
Yeah. A question, why not even a default judgment sanction? How do judges decide what level of sanctions are appropriate for when there's clear intent to deprive?
I mean, it depends on whether the intention is central to liability, merely has to do with damages, is merely peripheral. I mean, you don't want to throw out somebody's case or throw out somebody's defense where the information is likely to be peripheral. So it's a sort of a question of the least appropriate sanction that fits the crime, to let the punishment fit the crime, to quote Gilbert and Sullivan.
Right. Yeah. Somebody's, asking what's the smell test, but right. Yeah, great point. And someone's asking, is sending a legal hold notice doing nothing to preserve mobile device CSI? Well, talking about collaboration apps, but I mean, I guess really regardless of source, I guess it sounds like it's not necessarily always having that impact, or at least, maybe in this case, they didn't get
I mean, I would
notice, right?
I would say merely sending and forgetting is not going to be effective.
Right.
Sending, following up,
Right.
making sure the employees are doing whatever they're instructed to do in the hold notice, etc. I mean, all of this is, depending on the factual context of each case, but, actually going out and destroying company evidence is never a good activity.
Yes, that's something that will never change. So now for the contacts page, and we have a date for our next case law webinar, which will be the top cases of the year. As Mary pointed out, it will be on eDiscovery Day. Please make note of the special time. I do believe that's correct, 1:30 p.m. Eastern instead of our normal 1 p.m. Eastern. And also, as Mary pointed out, there's a link to the webinar in the attachments, so go check that out. And the full agenda for eDiscovery Day will be released, I believe, this Thursday. I believe that's going to be the announcement, and eDiscovery Today will cover that, so you can look for it there as well. So with that in mind, I will say thanks to Mary, Tom, and Judge Peck, as always, for their terrific insights, and I'll turn it back over to you, Mary.
Well, thanks, Doug. And if you look at that paperclip, you'll have a link to the website to subscribe to Doug Austin's eDiscovery Today blog. You can learn more about how you can engage Judge Peck of DLA Piper to assist you. Check out Tom O's Spicy Techno Gumbo blog, and then the link to sign up for eDiscovery Day's important case law decisions of the whole of 2022. And then up next tomorrow, eDiscovery Forensics for an Evolving Digital Landscape. And after the end of the webinar, check at the top of the Counsel for your certificate of attendance. So thank you, Doug, for anchoring as always. Tom O'Connor, the Honorable Judge Peck, for this wonderful, insightful presentation. And our thanks to the EDRM community for your kind attention. We'll see you next time on the EDRM Global Webinar channel. Thank you.
Thanks, everyone.
Bye, everybody.
Bye, all.